The Supreme Court just dropped a 9-0 ruling that threw out the old split-second defense cops have leaned on for years. And this one's big. It changes how force gets judged in traffic stops, police shootings, and maybe even regular self-defense cases. Hello, everyone. This is Sully from Line 45. Today, I'm going to explore how this ruling is going to change the way courts look at police force and self-defense from here on out. Before we dive in, do me a solid. Smash that subscribe, tap the bell, hit all the dang buttons down there. You don't gotta, but it keeps this train rolling and lets me crank out more of this wild gun talk for y'all. All right, enough of that. Let's get back to it. The shocker nobody saw coming. I'll be real with you. I didn't expect to see this. The Supreme Court just went 9-0 on a case called Barnes versus Felix, and that almost never happens when we're talking cops, guns, and constitutional rights. What they did was toss out the Fifth Circuit's moment of threat rule. That was the idea that you only look at the exact split second when an officer says they felt threatened, nothing before and nothing after. The court said, nope, that's not how it works. You've got to judge use of force under the whole picture. Just like Graham versus Connor laid out years back. Here's why this even mattered. Back in 2016, near Houston, a cop named Felix pulled over a guy, Ashton Barnes, for toll violations. Barnes tried to take off. Felix jumped onto the driver's door sill. The car started moving, and within about 2 seconds, Felix fired 2 shots and killed him. Lower courts looked only at those last couple of seconds and said the shooting was fine under that split-second rule. The Supreme Court said that's way too narrow. They said judges have to factor in everything. What led up to it, the choices made along the way, and what a reasonable officer should have done in the entire scenario. This wasn't the court deciding Felix was guilty or innocent. They're just saying the old shortcut is gone. Now the case goes back down to be retried under this new, bigger lens. From toll violation to gunfire. So let me walk you through what actually went down that night, because the details matter. It was October 2016, outside Houston. Officer Felix spots Ashton Barnes driving, and he knows the car's tied to unpaid tolls. Nothing violent, nothing dramatic, just a traffic stop over money owed to the toll system. Felix pulls him over, and at first it looks like a normal stop, but Barnes doesn't want to deal with it. Instead of sticking around, he decides he's going to take off. Here's where everything spins out. As Barnes tries to pull away, Felix jumps onto the door sill of the driver's side, basically hanging off the car while it starts to move forward. It all happens fast, literally 2 seconds or so. While he's clinging to the moving car, Felix pulls his gun and fires 2 rounds into Barnes. Barnes is hit and later dies. The whole incident from start to finish is just a blink compared to how long these cases drag on in court. Now, the reason this hit the court so hard is because of that split-second decision. The Fifth Circuit said, you only look at those final 2 seconds, where Felix was hanging on for his life, and in that snapshot, it looks justified. But what the Supreme Court pointed out is that the setup matters. Barnes was fleeing a toll violation, not attacking with a weapon, and Felix made the choice to step onto the moving car. That's the background. Next, I'll explain how the lower courts handled it. The old rule. When this case first moved through the courts, the judges leaned on a doctrine the Fifth Circuit had been using for years, called the moment of threat rule. The idea was simple on paper. You freeze the frame at the exact second an officer claims they were in danger, and that moment alone decides whether deadly force was reasonable. Everything else, like how the stop began, the officer's choices leading up to it, got shoved aside. That shortcut pretty much determined Barnes' case from the start. The lower courts only cared about those final seconds with Felix clinging to the side of the car. Looked at that way, the shooting came across as justified, and Barnes' family couldn't get traction. The fact that it all started as a traffic stop over tolls, or that Felix stepped onto a moving vehicle, didn't factor into the analysis. You can already see the flaw. Life doesn't play out in single snapshots. By only weighing the split-second danger, the courts let officers escalate a situation and then hide behind fear once it spiraled. That approach drifted away from what Graham versus Connor originally required, which was to weigh the reasonableness of force under the full circumstances. That's the framework the Supreme Court just rejected, and the replacement standard shifts the conversation in a big way. The Supreme Court's pivot. The Supreme Court didn't just tweak the Fifth Circuit's approach, they scrapped it completely. In their opinion, written by Justice Elena Kagan, they made it clear that use of force cases have to be judged under the totality of the circumstances. That's not new language either. It goes back to Graham versus Connor in 1989. What's new is the court telling lower judges to actually follow it instead of carving out shortcuts like the moment of threat. So what does that really mean? Instead of narrowing in on 2 seconds of chaos, courts now have to step back and ask what a reasonable officer would have done across the entire encounter. Was the stop itself minor or serious? Did the officer put themselves in unnecessary danger? Were there safer ways to handle the situation before it got violent? Those questions are all back on the table. Kagan laid it out in plain terms. Context matters. An officer can't just create a risky scenario and then fire their way out of it while claiming fear. The court said reasonableness is about the bigger picture, not tunnel vision. And it wasn't just the liberal wing saying that. Justices like Kavanaugh, Alito, and Barrett agreed too. Kavanaugh even pointed out that yes, traffic stops are dangerous for police, but that fact doesn't erase the duty to weigh all the circumstances fairly. That reset changes how future cases will be fought, and it's already forcing people to rethink the fallout. What this means for police, citizens, and courts. For decades, cops had that moment of threat shield in their back pocket. Training, legal defenses, even how lawyers argued cases, it all leaned on that one split-second snapshot. Now the Supreme Court just ripped that safety net out. That means every police department in the country is going to have to rethink how they train on the use of force. No more banking on, well, in that exact second I felt scared. Judges are going to want to know what led to that moment, what options the officer had, and if they escalated the situation themselves. For citizens, this matters too. Think about it. The same standard courts use for cops also ends up shaping how self-defense cases play out. If you're ever forced to pull a gun, the court isn't supposed to freeze the tape at the trigger pull anymore. They'll be looking at the whole lead-up. Were you the aggressor? Did you have a chance to walk away? Did you make smart choices before it came down to pulling the trigger? That's a big shift, and it cuts both ways. And then there's the courtroom fallout. Lawyers are going to bring up this case in every excessive force trial moving forward. Civil suits that would have been dead on arrival now have fresh legs. Police unions aren't going to like it, but the law's the law, and the justices couldn't have been clearer. Bottom line, the totality rule forces everybody to slow down and look at the big picture. That's good for accountability, but it also means more messy, drawn-out fights in court. And that brings us to what happens next with Barnes' case itself. The road ahead and why it matters to you. So the Supreme Court didn't actually close the book here. What they did was send Barnes versus Felix back to the Fifth Circuit, and that's a big deal. It means the lower court has to look at this case all over again, but this time under the totality of the circumstances rule. They can't just freeze the tape at those 2 seconds where Felix was hanging on the car. Now they've got to factor in everything that led up to the shots, and whether pulling the trigger really made sense in the bigger picture. That gives Barnes's family another chance they never had before. The case that looked dead is now back on the table, and the courts have to deal with all the context they ignored the first time. How that plays out could set the tone for every other excessive force case in the region, maybe even beyond. For police, this is going to change how lawsuits are fought. The old shortcut defense is gone. Departments and unions know training and policies have to adjust, because judges will be looking at decisions officers made before things got dangerous. For regular folks, the same idea carries over. If you ever have to use a gun in self-defense, courts aren't going to just look at the second you fired. They'll weigh the whole situation. This ruling doesn't say Felix was wrong or right. What it says is that the whole story matters, and that shift is going to ripple through courts, police training, and self-defense law for years to come.